Yes, Mr. Summers.
Lord, the next case in the list is a case called Wiley, and it's at tab 37 in the additional bundle of authorities that was supplied to the court.
What's this going to tell us, Mr. Summers?
It's going to provide authority from the First Division and the Second Division that if you want to eject summarily somebody who's got title, ejection is not the remedy, and that it's an action of removing. I could just step my way through judgments and take out the little sections that support that proposition. If I may read briefly from the short head note, a bond in disposition and security of a loan to be repaid by monthly instalments declared that in the event of any of the instalments falling into arrear for 2 months, the creditor should be entitled to remove the debtor and his tenants and to enter into possession of the subject and let them withdraw the rents, and that 1 month after intimation by letter of his intention to do so, quotes, without any warning or legal process whatever. It was held by a majority of 7 judges, with Lord Ardmillan dissenting, that a petition to the Sheriff to enforce this obligation by summary removal of a debtor who had fallen into arrear was incompetent. I'm going to make sure, my Lord, not to take my Lord to those bits where we're debating Sheriff Court competency, but rather to the statements of principle. If my Lord turns over to page 259, my Lords will see there that just before Lord Cowan's opinion begins, that it was re-argued with in front of the First Division plus 3 judges from the Second Division. Now, the part that I want to take my Lord to is found in Lord Cowan's judgment at page 261.
Yes.
And in the first full paragraph, approximately halfway through it, there's a sentence that begins, a summary ejection process.
Yes.
A summary ejection process before the Judge Ordinary is the remedy open to a proprietor against parties who have taken possession of a subject without right or title and are in truth mere squatters. The petitioners are not in the position of owners in any sense so as to justify such an action.
Yeah.
So that's the short chat.
Yes.
Lord Dees, at the foot of the page, again, succinct statement of the principles, the second line of his judgment. It's quite settled, I take it, that if the petitioners had held a bond in disposition and security in the ordinary and everyday form with which we are all familiar, they could not have taken possession of this property except by means of a pinding of the ground so far as the subjects were in the natural possession of the debtor, and by means of an action of mails and duties so far as they were in the hands of the tenants.
And what is pinding?
Pinding is an ancient Scottish form of procedure by means of which, in satisfaction of a heritable debt, can attach movable property in the estate of the debtor.
But is it a court process?
It is, but it doesn't arise in this action at all. It's just what's called a form of diligence.
But it's not a self-help remedy?
It is not, no.
No. That's really what I'm getting at.
Yeah. Over to page 269. This is Lord Ardmillan's dissent. However, his statement of principle is clear enough. It's at the middle of 269, in the second full paragraph, which begins, I have carefully considered. 5 lines in, there's a sentence that begins, an heritable creditor cannot remove the owner of heritable subjects by summary procedure. Do my lords have? Mm-hmm. Now, what his dissent was because he was of the opinion that it was possible by private contract to oust those rules. Now, that's not an issue that we need to concern ourselves. Now, Lord Neves, page 271, another statement to the point. Page 271, about 10, 12 lines up, down from the top, there's a sentence that begins, now the present case is a very peculiar one. Do the lords have that?
Yeah.
Now, the present case is a very peculiar one. I see it suggested that the true ground of application is a personal agreement on the part of the appellant to remove in a certain event, and it is pleaded as if the feudal or dispositive clauses of the deed were of no consequence to that question, and if a man grant a letter or an IOU and puts at the end of it, if not paid within a month after so-and-so, as certified by your clerk, you shall enter into possession of my house and premises, that personal agreement can be enforced in the Sheriff Court. Now, I entirely demur to that, and for the reason, among others, and for this reason, among others, that I am not aware of any instance or example of such a proceeding. A case of this kind comes to this. Now, it's this sentence that really I focus on, that a man, without even the shadow of a heritable right, but with a mere personal obligation from a proprietor, who still remains the true proprietor, can ask the sheriff to turn out that true proprietor out of possession. I never heard of such a case. And then the last, the penultimate rather, statement of the point is at page 273, and this in the opinion of Lord Kinloch. The second full paragraph begins, I do not feel called on to decide at present whether the creditor in the bond can, by virtue of the contract, enter into possession of the subjects without the usual forms of diligence, as for instance by a process of declarator and removing before the Supreme Court. It is enough for the disposal of the present case to decide, as I concur in doing, that the creditor could not competently enforce his right by summary process of objection before the Sheriff Court. Now, the last point is a jurisdiction point, but in the first sentence, what he adverts to there is what he calls the usual forms of diligence, as, for instance, a process of declarator and removing.
Declarator and removal is what they should have been doing, is that right?
Yeah. The Lord President is Ingalls, and at the foot of the page that we're reading, just one line up, he says, it's quite a coy expression of opinion, but I'll advert to it nonetheless. Now, the first question which arises is whether upon the occurrence of these events, the creditor in this bond can lawfully enforce the clause of removing against the debtor. And that involves the question whether such a clause is effectual to a party possessed only of a temporary and redeemable title against another party who is feudally vested in the estate in absolute property. That is a question of considerable importance, and it is not one upon which I am going to give an opinion. And then he goes on to dispose of the matter on the grounds of the jurisdiction of the Sheriff Court. So nothing emanates from that, save that he says it's a very important question, and he is not going to express a view on it.
So he's saying it can't be brought in the Sheriff Court at all. Indeed.
Yes, that's right. That's the burden of this case is the jurisdiction question. But these sections show, in my submission, the
And going back to the declarator, which you may think I'm fixated upon, but what is the nature of the declaration that would be sought, or declarator that would be sought?
As I understand it, what the party would seek to have the court find and declare is that there was a contract between the parties which stipulated that in the event of non-payment of a sum of money or some payment of some description, that the proprietor would forfeit possession.
Might be an idea, Mr. Summers, if you got some of your colleagues to copy a style, a precedent of for out of the style book of an action of removing, which would give us the declarator and so on, and show us actually what it would be.
Yes, I do recollect looking in Green's Encyclopedia of Legal Styles and not finding one, but I shall endeavour to look again.
I imagine there must be one.
Yes, yes. I'm not clear if there's one in this building.
I don't
No,
know
I was saying that
here.
maybe you could get one of the colleagues in Edinburgh maybe.
Yes.
But do I understand you to accept that under the 1970 Act, that process would still be available to the bank?
Yes, yes, it is,
In which case you could bypass Section 5 altogether.
yes.
So any notice that had to be given would only have to be given in the course of the declarative proceedings. Is that right?
That's the kind of the
Is that right?
That's right, my lord. That's really the real sting of my submission, is that Section 5 is there to innovate on the common law, to
I follow that.
deem somebody who's...
But if the bank decides not to do that, let's say not to, but simply goes by way of declaration, then you bypass Section 5 altogether, which makes Section 5 broadly irrelevant.
Yes.
So how is Section 5 relevant here?
Well, because the writ, which we actually don't have a copy
I was
of.
going to ask you about that. I was
I'd
just
like
going
to
to...
see the initial writ, because that will have the craves set out in it, and unfortunately the sheriff's judgment doesn't actually narrate exactly
I
what was
thought I
craved.
saw it in the core bundle, but I may be wrong.
I'm sorry?
It's not in the core bundle, my lord.
Is it? I didn't, maybe my mistake.
just looking for that.
I couldn't find it.
My Lord, my Lady, if I might assist, there are
Yes.
copies of the pleadings in the supplementary appendix.
It's page 3 of the supplementary.
Thank you very much.
Sure.
Thank you.
I'm grateful for that.
So just while we're turning to that, would it be right to say that one of the purposes of Section 5 was to reverse the effect of Wiley's case, although subject to the proviso in the case of property in personal possession?
I think that would be a fair way of characterising.
Thank you.
Yeah.
Yes, so the writ at page 3 is simply asking for a warrant to enter and to eject,
That's right.
which is the summary process indeed.
But how would you formulate it if it wasn't by way of summary process? You'd ask for a declaration, and then what?
You would ask the court to find and declare that you had a contractual
Yeah.
right. Then you would ask the court to pronounce a decree of removing, and if in the events that happened, the proprietor refused to move voluntarily, you could then compel by ejection, because he.
So you could still compel by... So you could get an unless order, as it were, could you?
Yeah.
You could say unless payment by X, unless the defender has left by date Y, then he's ejected.
Yeah.
Is that right?
I think there might be a number of ways of formulating the action, but that certainly would be one competent way of doing it.
But you need to have the declarative granted in your favour first.
Indeed.
wouldn't you? I mean, that's a necessary part of establishing the right to remove the person who has the title to be there.
That's correct.
And one
Could you
see
ask the
that-
sheriff?
Sorry?
I don't see why.
Could you ask the sheriff?
Well, that's why I'm a bit surprised in the earlier cases they said the sheriff had no jurisdiction, because I would have thought you could get a declarative from a sheriff. Is that right?
Well, it's I have this recollection from my days in practice that there was a terrible trap about removings and ejections, and I just remember that something was in the sheriff court not competent, or in the court.
Is my lord remembering the dreadful trouble that there was over ordinary procedure in the sheriff court?
I
and
just
summary?
remember getting papers on these things and thinking, oh God, it's one of these things.
Yeah.
Where do you do it? Which action is it? And that
Yeah,
sort of thing.
I think what my lord may be remembering is that there was widespread disputation amongst sheriffs about whether in the sheriff court, because ejection was being sought, it had to be by ordinary procedure.
I don't think I ever penetrated the details of sheriff court procedure, but never, I don't know.
Yeah.
Anyway, perhaps we could get it would be interesting to see the proper declarative, because it presumably declares that their right to occupy the property or something has ceased, or something like that.
Yeah, I mean, if one looks at Wiley, I mean, I would love to stay with Wiley because it's a fascinating case, but it's not, apart from the little section, it's not in point. But that's what was going on there, is that the creditor there tried to provide at his own hand a contractual route through possession, and got a debtor to agree that if he failed to pay in the manner specified, then he agreed to allow, without any process of law, entry into the subject.
We don't have an action of removing among the authorities.
No, my lord, we don't. No.
But this was a summary process. The one used by the bank in this case was a summary process. I see that, yeah.
It's two summary warrants that are being sought.
Yes.
It's going straight to warrant without having gone through the
Yeah,
action.
yeah.
And that's exactly what was sought in Wiley. Wiley was looking for a warrant
Exactly.
as well.
Has the warrant been granted?
No, my lord, the warrant was,
Sheriff refused to
Refused.
grant
He
it.
refused, and then what happened in the inner house?
well, the inner house, I guess, I haven't not checked, but it must have granted the warrant.
That's what I was asking.
Yes.
Did they?
I don't
The
recollect.
grant decree is craved, they say, which presumably means
I think that's shorthand for grants the warrant.
yes,
Yeah.
yes.
The
And you
clearest,
say the sheriff would have had jurisdiction on a, whatever the opposite of a summary process is, would you?
yes, he would have done that, yes. Because the act is designed to permit summary procedure. So he had there's no issue of jurisdiction in this case.
It's not
No,
summary
my lord is
procedure.
asking whether the sheriff would have had jurisdiction in the non-summary procedure.
Yes.
I believe he would have, my lord, yes.
Well, I suspect something has happened since Wiley to allow a sheriff to
The
do it.
1907 Sheriff Court Scotland Act
Yes.
is what happened.
Because it was a 1907 Act.
Yes.
Yes.
And the later statutes, and I suspect they enlarged the jurisdiction of the sheriff.
Yes.
That's my understanding.
Nearly all the sort of stuff to do with heritable property was peculiar to the Court of Session before then.
Yes.
And then, unhappily, it was all sent off to the Sheriff Court.
So really the mistake they made here was, it was the summary process was the mistake they made here, the bank.
Yes, that's the problem. I think the clearest exposition of them all is in the next authority, which is number 38.
Yeah.
And it does rather demonstrate an interesting feature because the Lord President, who is Ingalls, who simply states it's an important question but he's not going to express an opinion, 10 years later, still Lord President gives a beautiful exposition of what evidently he now conceives to be the true position. It's a Scottish property case. May I just invite my Lord to read the rubric while I'm reading it out loud?
Yes.
And at page 739 we see it's the Lord President, who still during the presidency of Lord Ingalls. And at page 740, around about halfway down there's a sentence that begins, now the question is this a case for summary ejection? Now the question is this a case for summary ejection? To warrant that, the possession must be either vicious possession, that is obtained by fraud or force, or precarious possession, that is to say without a title. In this case there is neither. There is no question of vicious possession. A precarious possession is a possession by tolerance merely. But this defender is here in virtue of ownership and under the rules of the society. The law on this is very clearly settled, and I need only refer to the case of Halley against Lang, the rubric of which is a petition for summary ejection, which contained no allegation of vicious or precarious possession, without title, held incompetent. And then there's a little section where he quotes Lord Deas for 3.5 lines, and then he picks up his disposal with these words, an ejection. An ejection is only competent where a party is either a vicious possessor or a precarious possessor in the sense of having no title at all, and the party asking ejection must set forth something sufficient ex facie to support his application. I am therefore of opinion that this petition stands properly dismissed. Lord Deas, the part that I would direct my Lords to is 6 lines up from the bottom, where he says, I think this action is ruled to be incompetent. By the case of Wiley, I mean incompetent on principle. A warrant of ejection is not a decree but a diligence. The question therefore is whether private parties can make rules for themselves applicable for diligence quite different from those of ordinary law.
Yes, it's quite interesting. The earlier sentences show that since Wiley, the jurisdiction of the Sheriff Court had actually been extended,
been.
so one can see that process beginning.
Yeah, that's right.
and he doesn't like
it was
to.
a monetary expansion of jurisdiction, and then
Yes.
it expanded again in 1907.
Am I right in thinking that diligence means enforcement?
Enforcement for debt, yes.
Yeah.
Yeah, I think I anticipated this question, so I have a quotation from Lord Erskine in his institute. He says that diligences are forms of law by which a creditor endeavours to make good his payment by securing his estate from alienation or embezzlement, or by carrying the property of it directly to himself. That's one of our institutional writers, so I hope that clears it up.
And what's the difference between a decree and a diligence?
Well, that's what I meant.
Well,
What I was getting at, isn't a decree the order of the court, and isn't the diligence the way of enforcing it?
that I think is correct, and I think the reason why the court here describes simply asking for a warrant to eject is that what they're simply approving is that which would otherwise come to them by means of court order. So they are turning somebody out, just authorising somebody to turn somebody out, and that is a form of diligence.
You wouldn't get to a warrant to do diligence until the decree had not been implemented. Would that be right?
Yes,
if you go the ordinary process, an order is made, and it's only when the order is not actually implemented by the defender that you would get round to getting a warrant for some exercise of diligence to have a sheriff officer or a messenger at arms carry the process out for you.
Yeah. It seems that what Section 5 is designed to do is to go straight to the point at which the diligence is effected.
That's
And my Lord and the Chair and my Lord Roger will be excessively familiar with the approach of law to diligences, which is to treat them strictly and not allow a latitude in how they are handled. And I would invite my Lord to look at this case and say, one ought to handle this case in strictissimi juris. They have not done what the section seems to require them to do, and that is the end of it. One ought not and need not look for any way out.
What does infeft mean?
It means to have a registered title, my Lord. I think that is...
Good shorthand.
Yes, that's right.
Is there a Scots law dictionary, as there is?
There is. There's one or two good ones, my lady. They don't always have the definitions that one is seeking for, but...
But I think that if I can put it this way, that when you transfer the ownership of a house, you deliver the disposition, but you don't become in theft until the disposition is recorded in the register.
That's correct.
And when it's in the register, you then have a title which is good against all the world.
I think that expression, it begins, if one is to try and fully understand it, would require an exposition of how feudal conveyancing worked and taking seizings and so on and so forth.
Well, we used to do that, but it didn't need a register. We used to have something called thefment with livery of seizin.
Yes. The register superseded all of that, and you could achieve it by paper instead of by a trowel and bits of clods of earth and so on.
Yes, indeed, and many symbolic acts of taking seizing, not just clods of earth, but some other very remarkable things. But
sorry, on you go. I was just wondering where we go from Horn, because the next step, I imagine, is Section 5, isn't it? Which cures the problem.
Yes, my Lord. That completes my attempt to set out before your Lordships what the underlying law is. So if we look at Section 5 in the light of what we learned, and this is, it may be to cover ground again adverted to this morning, is really what one gets from, for example, the cases like Ingalls, is where you find in Section 5 the expression an occupant without a title. What that is saying is that that's a squatter.
Deemed to be.
Deemed to be.
Yes.
Yeah.
So that if that's the position, if he's deemed to be that, then he's in the position
Yeah.
where he would be entitled to a warrant.
Yeah. And the deeming provision is necessary because the legal position is that he is an in-theft proprietor.
Yes.
Now, Section 5 also refers to the concept of possession. Unless my lords wish me to do so, I don't think it's necessary to explore possession. Perfectly, I would suggest, straightforward here that there may be 101 ways where a bank may enter possession, change the locks or whatever it might be, but what one has here is somebody in actual occupation, which is elsewhere called natural possession. What one is doing is simply turning him out.
Are you going to tell us about formal requisitions?
Well, that's my next argument. I think that is my argument set out in connection with my first proposition.
Yeah.
I don't think I need go further.
So the second point is the formal requisition.
Yes, it is. In its own way, this is a wider point because it is directed at the demand letter that was sent. Now, if we look at tab 8 in the bundle of authorities, this is the 1868 Act, which was a consolidating statute. My Lord will see at page 719, the opening 4 lines indicate that it collates the law relative to heritable securities. Then we have, in the following page, section 119 laid out in all its glory. It runs to 3 and a bit full pages. Daunting at first sight, but then when one realises that without putting in numbering, that it is really just an explanation of how the document that is reproduced at page 846 at the rear, schedule FF.
Did you say 846?
Page 846 of the statute.
Yes.
Schedule FF, and that is a form of a bond and disposition of security. And section 119 is effectively an explanatory note as to how that...
I'm just cross-checking against Schedule 8 of the 1970 Act, and it refers to Section 119 in Schedule 8 as being explanation
Yes.
of the clauses.
Yes. Now, if one looks back to section 119 and looks at page 790 towards the end of the second page, in the explanatory section there's a sentence that begins, and as if it had been thereby.
So where's that?
Yes.
It's near the foot of page 790.
38 lines and foot.
Oh, yes.
And as if it had been thereby...
This is after the semicolon, no?
It is exactly so, after the semicolon. And as if it had been thereby further provided and declared that if the grantor should fail to make payment of the sums that should be due by the personal obligation contained in the said bond and disposition of security within 3 months after a demand of payment intimated to the grantor, and so on and so forth. So that's the expression used there, the demand of payment. And if one looks...
Does one read that with the first 3 words of Section 119, that the import of the clauses
Yes, my Lord.
shall be as follows, and passing over the rest of it,
Yes.
as if it had been further provided?
Yes.
Which demand will be in the form number 2 of Schedule FF.
And my Lord Rogers ahead of me then goes over to
Yes.
form number 2, and that is headed up a slightly different expression is used. It's a form schedule of intimation, requisition, and protest. And I think that is just a more accurate way of describing what is contained in the notice, which is that it intimates to the debtor, it requires payment, and the protest is, I am sure, the warning as to what dreadful consequences will ensue if he doesn't comply.
Payment is now required.
This is a bond given by the borrower, is it? Or
Yes, my lord. Yes, it is. Yes. And what number 2 is, form number 2, is an example of how in 1868, at the time the Heritable Securities Scotland Act was enacted, this was how a demand of payment, or to give it its full name, an intimation, requisition and protest was effected.
Form number 2, about 8 lines from the foot of it, says that assuming that money has not been paid up and so on, that the holder of the bond may proceed to sell the lands,
Yes.
thereby conveyed, with all the powers and privileges conferred on all competent creditors under bonds and security by that Act. That's the 1868 Act. So where does that leave cases like Wiley and so on? Where does that leave Wiley? I mean, does it allow you to proceed summarily, or are we still awaiting Section 5 of the 1894 Act before you can proceed summarily?
Yes, my lord, that is correct. The narrower point to which I take from this is that I'm putting before the court,
Yes.
if you'd asked a conveyancer when the 1894 Act was enacted, what is a formal requisition?
I see, yes. This would be the thing you
That's
would
what they
look
would
at.
think of.
Yes.
That's my simple point.
This is in other words warning you when they're going to sell your property.
Yeah.
Is that right? Which is what the 1894 Act is concerned with?
Yeah. Well, ultimately, it will come to that. Yeah.
But it's certainly what Section 19 would be, isn't
Yes.
it? It would be that.
And the word
And
requisition.
here you're trying to get the same thing, aren't you?
What I draw.
and this covers the enforcement of security in circumstances where the person you're proceeding, the occupier, as it were, may not be the borrower.
Yes, my lord. Yeah. It's a kind of very modest point I draw from this, which is that if one looks at it, what one sees is a formal, one would say excessively formal demand, but all the relevant details, the names of the parties are fully designed.
Yes.
The underlying securities details are set out, and the consequences of failure are spelt out. And what I would respectfully submit is when one finds in Section 5 a requirement that would be a formal requisition, that this is the sort of formality that the drafters of the Act had in
And what
mind.
was the purpose of it in this Act, in the 1868 Act?
Well, the purpose was to...
Well, the purpose of giving this form, and what was the form for?
It was first to demand payment, and on default, and if there was default...
Yes, but in what circumstances would you be required to demand payment?
If there was breach of the...
But was that under a statute?
Yes, my lord.
Which one?
Well, that's
no,
the
no, not
first
the
bit
bond,
of
no.
119 you showed us, isn't it? The foot of page 790.
Yes.
Yeah. And as if it had been thereby further provided and declared, etc.
Yeah, but...
But
It's doing rather more than expanding on the form, it's expanding on the content of the form
Yes.
as well as explaining it.
yes,
The reason I'm asking this question is that we're discussing Section 5, and we've been discussing a declarator and so on. But if you were proceeding by way of declarator before Section 5 was invented, no question of a summary process, would there have been some provision of a statute which required you, before you started the proceedings, to serve a requisition?
Well, if it, as I understand it, if the security was in the form of a bond and disposition in security, that what that bond did was place the obligation on the creditor that if he wanted to enter into possession, to serve a notice of the type that we find here. So to that extent it would be a contractual matter.
If it was in the bond?
Yes.
But it was a matter for the parties to decide whether it was in the bond, was it?
I think so, my lord.
So it didn't have any statutory force?
Not
I mean, what statutory... Are these just sort of forms available to the draftsman, or did they have some other...
That is my understanding, my lord.
There was a great vogue, wasn't there, in late Victorian times, both in England and it seems in Scotland as well, to try and shorten conveyances
Exactly.
by providing for statutory forms.
Yes.
And that is what the whole of this long statute is about, isn't it?
I think we can see that page 791, about 4 lines down, that if you fill in Form 2 and it's certified by the notary public, that shall be sufficient evidence of the demand.
Yes.
And then it goes on. On 790, the clauses reserving blah, 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 and on default in payment granting power of sale shall have the same import and shall be in all respects as valid, effectual and operation as if. And then that's where the as if gets carried down to. So it's, as Lord Walker says, these are short clauses and they're to be interpreted as if they're provided for these various...
Yes, madam.
Which is what I meant when saying it's expanding upon the form.
That's exactly.
So we have these forms in the 1868 Act, but I think I'm right in saying there aren't any forms annexed to the 1894 Act.
None. No. And so what I'm really trying to do is provide my lord with material that will assist the court come to a view.
In 1894, this would still have been in operation.
Precisely, my
Yes,
friend.
and you say that reading Section 5 in 1894, it would not be difficult for someone who knew about conveyancing to recognise what a formal requisition was.
That's exactly my submission.
And indeed, if there are any of these still alive, a requisite, it would still apply to this day.
Indeed. Now, happily, I can not only point to a statute just before 1894, I can come forward a little bit in time and look at a statute in 1924.
Yes.
And again, we find similar sort of material. And that requires us to look at tab 1.
So we have forms attached to this Act.
Yes, we're going to first read section 33, just at the foot of page 127. Without prejudice to his rights and remedies under the personal obligation, the creditor in a bond and disposition in security or any part thereof, whether dated before or after the commencement of this Act, may serve a notice calling up the same, in or as nearly as may be in terms of Form 1 of Schedule M, and so on. And it's, now, just before we go to that form, can I point, my lords, to section 34, and it's at the top of page 129, where it's discussing service of the notice. My lords will notice just in the middle of that paragraph there, such notice shall be deemed to be formal requisition for all purposes, including the purposes of the Heritable Security Scotland Act 1894. Now, I cited this in the Inner House, and it was quite correctly thrown back in my face, because
I haven't found that. Is it
it's
section
just
34?
halfway through,
129, Tom.
at the top of page 129,
Such notice.
4,
Oh, yes,
5,
thank you. Yes, yes.
Because I freely accept that it is just a deeming provision. It shall be deemed to be formal requisition. But my simple point is one, well, at the time, if you'd asked somebody what that suggested, in my respect, it strongly suggests that the sort of content that one sees over the page in the notice of the calling up of the bond, which is the Schedule M, is what the statute is saying is thought to be a formal requisition. Now, I suppose it may be that it's near as may be, and that one may get embroidered around the edges and perhaps a little bit more or perhaps a little bit less. But my simple submission is that if one looks at the demand letter, it's nothing remotely like this form of formal requisition. There's no reference to the security, no designation of the parties, no clarity as to the actual underlying obligation that's being invoked. It's just a common law demand for payment, that's all that it is.
And that was the forerunner, was it, of section 19, subsection 6? Except it doesn't seem to have the bit about the 1894 Act in it.
I didn't quite follow the start of what you said.
Well, I was just wondering whether or not there is an equivalent in the 1970 Act to section 34, and there is,
Yeah.
or much of it, which is 19, section 19, subsection 6.
Yeah.
Though that stops before it gets on to referring to section 5 of the
Well, if
1994
one
Act, I
looks
think.
at the only form which might be thought to be a formal requisition that is under the 1970 Act, and one finds it too is pretty full. That's Schedule 6.
Is that Form C?
Form C. Well, notice of calling up is Form A.
Form A.
Form C is an acknowledgement.
Yes.
That's at page 44 of the 1970 Act, just at the foot, Schedule 6,
Oh, I
notice
see,
of calling up.
yes.
Form A is remarkably similar
Yes.
Yes,
to
indeed.
previous forms we have looked at.
Precisely so.
And if we look at page 47, we see that Schedule 8 of excluded enactments includes the Conveyancing Scotland Act 1924,
That's right.
the sections we've just been looking at.
Yeah. So that is my submission on that point. All I say is that if when one inquires as to the meaning of that phrase, what is a formal requisition, and one finds material in the conveyancing statutes before and after Section 5 is enacted, one might suggest that these forms require something full and detailed, and in particular, an indication to the proprietor that there's a security and your land is covered by that security, and if you don't pay, consequences will follow.
So in this case, what one has is what we see at page 194 in the appendix, do we?
Yeah, the notice of demand.
That's the 20th of June
Yes, the
letter.
June 20th letter.
What's the page?
Page 194.
Yes,
I think I'm right in saying that's
Yeah.
the letter on the basis of which the writ was brought.
Yeah, and I should point out, just for clarity, that it's a letter in identical terms was sent to the other Mr. Wilson.
Yes.
So there's no difference in wording,
Yes.
save the addressee. Granted, there are elements of formality in the letter, because in the undernote it specifies the sums due, and granted it is written in formal language, but what my submission is that is not what formal requisition means in Section 5.
Not least because it gives no indication that the security is in any way involved.
That has been the problem in this case.
Quite apart from it's not being addressed to both people.
Indeed.
Yeah.
Because, I mean, all it says is institute proceedings against you for recovery, isn't that? That's most of it says.
I think it's in finding of fact 7, and they're identical in both cases. What the sheriff heard from the witnesses and accepted as their evidence was that, first of all, the wives never heard about this until the action began. And secondly, the men that got it thought the bank was just going to come after us for payment. Their assumption was an action of payment was pending. And such was their embarrassment, they never thought to tell their good lady wives that that was due.
Yes.
I mean, we would need to look at it, wouldn't we? Wouldn't we? I mean, if you're saying it's got to be proper requisition, I mean, supposing that they had, it wasn't in proper form, is that, I mean, would you, supposing that they had said, oh, you know, because let's say he were a conveyancer or something, say, oh goodness, this is, they're going to come at me or something like that. Mm-hmm. That wouldn't matter if you were right, would it? Or would it? Mm-hmm. I mean, you say, as I understand it, this is not good enough.
That's basically it, yeah. I mean, I don't require to examine all sorts of possible scenarios where it gets more and more formal, and the question is whether it finally slips over into formality. What I say is, the heart of what I'm saying is if you look at the formal requisitions in the statutes, the big thing that they are doing is laying out in formal terms the foundation upon which the demand is made, the basis, the contractual basis of the right that is being exerted. So you own this land, you granted this security, we are demanding payment of you.
Well, it must be a notice to the proprietor.
Yeah. Yeah.
Or to the relevant proprietor.
Yeah. I mean, looking at the word formal, I don't suppose it's got so much to do with archaic language. It's not really that's in use. The formality doesn't consist in the words selected, I would suggest. But I would suggest what formality imports is the punctilious care with which all the necessary contractual material that provide the foundation for the demand is laid out in clear terms so that the debtor understands precisely what it is that is proposed.
But it's particularly with reference to the wish to enforce the security,
Exactly.
isn't it? I mean, it's perfectly clear reading the letter that payment is being asked for and proceedings may be taken to exact payment.
Yeah.
But that leaves unsaid the further step of wanting to enforce the security.
Yeah. If one glanced at this, a litigator might say this is a letter before action, just a warning.
Well, if it said, dear Mr. and Mrs. Wilson, and then said, against you for recovery and for possession of the secured property, that would be good enough.
Yeah, I suspect it would be. I'm not forced to confront that. I think if I was in that situation before this court, that I couldn't cavil that the words weren't the same as the forms, because in my submission, the point is to alert them to the foundation upon which the demand is made.
And if they'd applied for leave to amend their proceedings, to proceed by way of declarator, they could have simply put that in the pleading by way of amendment, couldn't they? And then they'd have been okay. That's right, though, isn't it? That's right, though, isn't it? If you apply to the sheriff who has jurisdiction, when they take the point, if they'd applied to amend the proceedings, simply to plead the things that you say should have been in the requisition, I understood you to say that'd be all right.
Well,
Yeah.
Myself, I doubt whether you could do that in a summary process, because you would be asking for something which wasn't available in the summary process. You'd have to
I think my Lord's point, though, is...
The English process was certainly flexible enough to have
I think my Lord's point
a claim
probably
that was partly considered summarily and partly considered not summarily.
Because it does seem, I didn't want to get into it because it's not necessary for this action, it does seem ultimately that, although a summary warrant is being sought, that it is being sought in the form of an ordinary action.
Right.
So...
You'd expect a flexible civil jurisdiction justice system
My Lord,
to be able to
amen to that. And a flexible jurisdiction ought to be able to provide a means by which the bank could remedy the situation by amending in a declarator, with the warrants then being tagged on to the end.
Well, I think the sheriff would then transmit it to his ordinary role or something like
He
that.
would.
Would he not? He would have to put it into some other different process, but it's all within the same sheriff court at least.
I can see he'd put another hat on. But,
My Lords may have the advantage of me. What is the heading on the initial writ? I have a recollection that there is something in the heading that suggests whether it's the ordinary role or the summary clause it's on. I may be wrong about that.
It's not easy to find anything. It just says Sheriffdom of Lothian and Borders at Edinburgh Conveyancing Feudal Reform Act.
An initial writ, you see, would ordinarily be an ordinary action.
Yes.
This is not a summary application. I think, my Lord, we're in danger of sliding into the
Yes.
10 years of disputation over what the correct form of process was.
Yes.
I follow that, but to my mind it's quite important because the reason for taking this case is to look at these processes and to see what they should be and how they should proceed in the future. So to know what the alternative to the summary process is, to my mind, is quite important. And speaking entirely for myself, and I know that I'm only English and don't know much about it, but it does seem, and this is undoubtedly a summary process, see the top of page 4.
Well, it's quite a... It's got all the appearance of an ordinary action with condescendence and answers and pleas in law and so on and so forth. It doesn't look like a summary process
does
to
not.
me.
Looks very unsummary, doesn't it?
Well, what happened, of course, is that the thing that the bank didn't want to happen happened, which is that the debtor began to fight, and he amended his pleadings, and the bank had to respond to that, and the pleadings began to exponentially
Trouble is
grow.
that they didn't amend to ensure that any issues of substance could be determined, namely what the liabilities actually were.
Exactly.
Well, I think we get some clue from what was going on at page 24, where we can see the first interlocutor appoints parties to be heard at an options hearing.
That's an
And
ordinary
then
action.
further down, we see the cause is remitted to additional procedure.
That's a
And
chapter
that sounds
10
to me as though he's
procedure.
doing exactly what Lord Clark is suggesting.
Yeah, that is exactly
in the
my
light of this-
understanding, is that this, although a summary craves are in there,
Yes.
as I understand it, the upshot of all the sheriff court cases was that it was accepted that this should proceed by ordinary action.
Yes.
I believe even there may have been an amendment to make that amendment to the Act to make that abundantly clear.
Well, an amendment was received in the middle interlocutor, so it looks as though there is, I'm not familiar with it, but it looks as though the options hearing allows you to decide what to do, and it was then moved to the additional procedure, which is an expanded procedure, which allows it to proceed as if it was an ordinary action.
I just make it abundantly clear that I'm not taking a procedural point here at all. I'm not arguing that it's in the wrong role or the wrong form.
I understand.
Mine is more.
My point is that the bank would have had a simple remedy. All they had to do was to apply to the sheriff to ask for a declarator, which would make Section 5 irrelevant, and then they'd simply ask for whatever you asked for in a declarator.
I think
Namely, they're pursuant to their security, they're entitled to possession, and then ask for an order of ejectment if.
my deep and
And they
profound
could perfectly well have done that.
my deep and profound suspicion is that there's not a solicitor acting for a secured lender in Scotland that had dreamt in his wildest dreams that we would be having this case today. I think Section 24, if they knew about Section 5, and some of them did, because I have spoken to some that do know about Section 5, is that they just thought that was, whatever the situation, was your summary road to ejection. But actually, when you begin to look at the words in the statute, it's not that straightforward.
Well, it is quite straightforward as long as they realise they've got to serve a formal requisition.
Precisely.
But the degree to which we're going to make all crystal clear for the future is rather limited, because the 70 Act has been quite extensively amended in 2001, isn't it?
That is correct, yes.
By the Mortgage Rights Scotland Act.
Precisely.
So, and we're just not looking at that at all.
No. Now, my Lord is right, is that that Act has not amended the law so as to require, to define what a formal requisition is, but what it has done is introduce, for a residential security, which is what we've got here, an obligation on the creditor, after he has obtained his warrant, is that right, John, to offer a whole variety of ameliorations of the severity of the of the remedy.
Yes, well, just glancing at what we've got at tab 3 without going into it in any detail, one can see that quite a lot of new provisions for the benefit of householders have been introduced.
I'm not sort of focusing, it's not necessary for this case, but my understanding is that these ameliorating provisions bite at a stage subsequent to the stage we're at in this case, which is once the warrant has been granted, as I understand it, the sheriff then has to consider all sorts of alternatives to just simply evicting, as I understand it. Yeah, Milano Junior says it's principle that may not be allowed time to people whose perhaps it's their only home to make arrangements so as to find housing.
And you've told us that the transitional provisions, whatever they are, for the Mortgage Rights Act don't mean that it doesn't apply to these proceedings.
Indeed, my lord, yeah. So that is my submission about the expression formal requisition, which brings me to my last proposition. Now, if we look at the core volume, page 156, just so we can see the point of this.
Core volume?
Core volume, page 156.
Yes.
This is the Sheriff Stoddart's judgment. And finding of fact 7, on the third line.
It's my fault.
Page 156 in core volume.
Yeah, in the core volume, page 156, Sheriff, this is part of Sheriff Stoddart's judgment.
Yes.
And the third line begins, the first offender received and read the letter, this is the demand letter, after it was sent to him. At that time, he did not understand it to mean that the pursuers would seek to repossess his home or eject his family, but they were seeking to recover sums of money due to them. And the second offender, that's the wives in other words, saw the letter for the first time in early 2007. Now, if you look at the way things unfolded, that's after the action had been underway for some considerable period of time. I actually remember the moment when I showed the wives this letter in some preparation for the proof. And that was, as the sheriff accepts, the first time that they had seen it. And she thought it meant that the pursuers were seeking to recover money from her husband. Now, it is true that what they thought is not decisive, that they thought that's what the letter meant is not the end of the matter. Of course it's not the end of the matter, it's for the court to decide whether that is what the demand letter means. But what I submit is that I don't know if my Lord required me to take it, but Lord Walker, in the case, the Privy Council case that's been put in, my Lord, have my Lord ever looked at the, I should perhaps just for clarity,
I think you better refer to it, yeah.
To it. It's just for it's such a tiny little statement of principle. It's tab number 17 in the first volume.
In the grill, yes.
Paragraph 40, my lords. And my Lord Walker is discussing a demand. This demand did not have to be, as the judge's order put it, a formal demand, but it did have to be clear and unconditional. And then my Lord refers to an Australian case, which is also in the bundle at tab 23. Now, the simple point of principle, I say, clarity is of the essence of a demand. Now, in this case, we know that, and the bank knew, that there was a basis upon which the husbands to whom these letters were sent could be made liable, that is to say the partnership letters. And I would respectfully submit that if the partners, or the former partners of this firm, received that letter, that demand letter, and you'd inquired of them, or one had inquired objectively, what is it that the bank are seeking to do, I would respectfully submit that what it would appear they're seeking to do is to enforce the guarantee.
It's the husband's guarantee.
Yes. 3 years actually ensued after that letter was written before any step was taken. A lengthy period of time went by before anything was done. But looking at that letter, knowing that there was a guarantee that the husbands had offered, I would suggest that it is at least potentially misleading when there is a quite separate document that it would appear that ultimately they intended to rely upon. So, in my submission, the fairest reading of the demands is that they were written to the husbands because they were liable under the partnership letters, and it was their liability the bank was focusing on, and the threat of court action was against them, the husbands. In the interest of clarity, if it was the case that the wives were going to be in any way held liable, that ought to have been spelt out. And that is that submission. These are my submissions in connection with the three propositions that I advanced at the outset of the case. The Inner House took a completely different route in this, and my learned friend, as it appears from his statement of case, accepts that the route that the Inner House followed, which was to treat a Schedule 7 certificate as if it were a formal demand, is not one that he seeks to support. All I therefore propose to do is to indicate to my Lord that the reasons why that is so are set out in paragraph 22 of my statement of case. I don't think we need to go over them.
So the purpose of the Schedule 7 certificates is to operate as prima facie evidence of the facts stated therein.
Right.
But your submission is that can't be a requisition within the meaning of Section 5. It's introduced into the Act, I think, by subsection 2 of Section 24, isn't it?
It just simply can't be a requisition because Section 5 says that you require payment and then you act, whereas the Schedule 7 certificate was lodged in process long after the action had begun. There's no words of requisition in it. It's just simply a means of expediting the evidence. Matters that would otherwise require to be proved in evidence do not require to be proved if a Schedule 7 certificate is lodged in process.
And when you say there are no words of requisition in it, do we see that if we look at page, is it page 195?
Yes. Yes.
I think the certificates, there are two of them in the bundle. One is at page 151.
Yes.
And the other is at 195.
Yes, a number of certificates were lodged in process after the actions were underway. It is, in my respectful submission, simply not possible that these should be formal requisitions. And that is not, I'm not taking time, because it's not argued that to the contrary effect.
Yes.
Unless there are any other matters, I should perhaps just advert to 2 or 3 of the questions that were raised by my lords during the hearing and indicate what we propose to do about them.
Yes.
Lady Hale asked for illumination as to what the Halliday report was all about. We will endeavour to provide that illumination, but we've not been able to achieve it over lunch. But we will seek to track down the report and furnish the lady with such parts of it as assist. My lord asked whether or not it was possible to evict without process of law, because I think eject rather without process of law. Now again, over lunch, it's not been possible to get to the bottom of it. I believe that both my lord and the chair and lords thought there was an English or a UK statute that covered both the situation in England and Scotland. We don't know what that is.
I suggested that. I believe there is a statute.
I think the original one was the Protection from Eviction Act 1970, although
Yes,
I suspect it's been reenacted. But
Yes, but I'm pretty
does
sure it's
that
a
apply
UK
in-
statute.
I was not aware of that statute, but I'll endeavour to track that down this evening. I don't think the case is going to finish today, so there will be an opportunity to try to sort that out.
Is the Halliday report, is it a command paper?
It will be, my
If
lord.
you gave us I suspect we can get it from the Lords or something.
We've tried to track down the command. I'm grateful.
1966, Command 3118.
My lord, hear that.
1966, Command 3118.
Is it CMD or CMND?
CMND
And the number
118.
again?
3118.
3118. Thank you.
I'm grateful to my friend. and the last point was Lord Walker's desire for a clear account of my opening propositions. What I'll do, my lord, with my lord's permission, is type them out tonight and supply them to the court tomorrow.
Well, I think all of us would find that extremely helpful. Thank you very much.
I'm happy to do that, my lord.
Thank you very much indeed. Yes, thank you. Mr. Robertson, do you want to add anything? Thank you. Yes, Mr. Baccarat.
My Lord, my Lady. I invite your Lordships and your Ladyship to dismiss these appeals and to affirm the interlocutors of the extra division which the appellants now seek to bring under review. My Lord, it appears that essentially it's accepted on both sides of the bar that there are 2 principal issues which arise for determination in these appeals. The first being whether the respondents have established in relation to the standard securities granted by the appellant that the debtor is in default within the meaning of standard condition 91B of the 1970 Act. If that is so, then it follows in my submission that the respondents are entitled to decree in terms of the first crave of the writ. And your Lordship has been taken to the craves, but it may be of assistance to look at the craves of the writs again, which are at page 3 of the supplementary appendix in the core volume.
Just while we're looking at that, was I right in what I was reading from page 24 about the way the procedure worked here?
Yes.
That it began as a kind of summary process, and the options hearing allows you to move into additional procedure. Is that right?
Well, no, my Lord. The position under the Act as originally enacted was that any application, certainly in terms of the first crave of this writ, for warrant to exercise remedies, had to be made by way of summary application.
Yes.
Summary application procedure is a variation of the ordinary procedure under which the Sheriff is given greater flexibility as to the various stages or timetabling of the procedure. As a result of an amendment to the Act made by an Act of Sederant, and I can take my Lords to it when I take them to one of the cases I intend to cite, but as a result of an Act of Sederant, the Act was amended so that any action of this kind in which a creditor sought not only a warrant to exercise the standard condition 10 remedies, but some additional remedy had to proceed by way of an ordinary action. So lest your Lordships and my Lady were to feel, as a result of the discussion so far, that in these proceedings the bank is somehow attempting to short-circuit the procedure which would have to be followed if these were instead actions of declarator. The procedure is precisely the same, and the appellants have had precisely the same opportunity to propone a defence in these actions as they would have had these actions been raised, as my learned friend is suggesting, as actions for declarator and removal. So this is not a summary procedure in the sense of depriving the resident of the security subject of an opportunity to propone a defence in any way.
Yeah.
And the bank has not selected this procedure as a means of somehow prejudicing the respondents, even if my learned friend were correct in his submission that these ought to be actions of declarator and removing, and in my submission, he's not well-founded in suggesting that. But even if he were correct in that, the procedure which would have been followed would have been exactly the same as has been followed as a result of the bank having elected to seek their remedies under Section 24 of the 1970 Act. And indeed, it was assistance that perhaps later we can provide to your Lordships and your Ladyship copies of the standard forms of crave in actions of ejection and removing in the Sheriff Court as provided in Dobie's styles. And your Lordships and your Ladyship will see that although there is a very slight variation in the wording, both refer to the word ejection and both have the same, entirely the same practical effect when decree is granted.
Yes, so you asked us to look at the craves at page 3 and 4.
Page 3 and 4, yes, my Lord, of the supplementary appendix. And it's simply, the point I seek to make at this stage is simply that if the extra vision were well-founded in holding that there has been a default in these cases by the debtor in the standard security, such as to entitle the bank, the respondent, to exercise the remedies of a creditor whose debtor is in default, then the bank are entitled to decree in terms of the first crave of the writ. And that will be so, I say, even if your Lordships and your Ladyships ultimately hold that as a consequence of that, there is no entitlement to ejection, even if the bank are to fail in relation to the second crave, they would still be entitled to a decree entitling them to exercise the remedies under Standard Condition 10, including the power of entering into possession of the security subjects. But in any event, I mean, I label that first issue simply the default issue.
Why does it need a warrant from the court to enter into possession?
Because the bank, in this instance, didn't take the option of serving a notice of calling up. Had the bank served a notice of calling up, then the bank at its own hand would have been entitled to enter into possession.
Under 10.2 and 10.3, may enter into possession of the security subjects.
Yes.
That's a power which is given on anyone on default.
Well, I was intending to take your Lordships and my Lady to the provisions of the Act dealing with this, but in summary, what I suggest is that where a creditor has served a notice of calling up under Section 19 and that notice has not been complied with, the creditor is then entitled, in terms of Section 20, to exercise all of the remedies listed in Standard Condition 10, and as the Lord Roger indicates, those remedies include the power of entering into possession, and should the subjects be vacant, then the creditor can immediately exercise that remedy by entering into possession. The Section 19 calling up creditor only requires the intervention of the court if the subjects are not vacant and the proprietor refuses to remove voluntarily. In that event, the creditor requires to seek the assistance of the court and obtain a warrant to eject. The creditor who follows the route of serving a notice of default, again, is entitled to exercise certain remedies at his own hand, although they do not include the power of entering into possession. They do include the power of sale.
Why do you say that?
Well, if I could take my Lord and my Lady to Section 20.
Puzzled. I see, 20 says that, does it?
Yeah.
I wonder if you could speak just a little louder.
I'm sorry, my lord, yes. At tab 2 of the first volume of authorities, we see that section 21 is the section indicating that the creditor may serve a notice of calling up. Section 23 is the section which provides what happens in the event that the notice of default is not objected to and is not complied with. And section 23 subsection 2 provides that subject to the provisions of section 21 subsection 4 of this Act, where a person fails to comply as aforesaid, the creditor, subject to the next following subsection, may proceed to exercise such of his rights on default under standard condition 10, 2, 6 and 7 as he may consider appropriate.
But that's the power of sale, the power to effect repairs, and applying for a decree of foreclosure.
Indeed, yes, yes. As my Lord the Chair indicates, those are the three powers which the creditor is then entitled to exercise at his or her own hand. Now, again, even being entitled to do that, it may be necessary, of course, to seek the assistance of the court if the proprietor or occupier refuses to remove voluntarily, because there's little practically that can be done about securing a sale of a property, one might think,
Yes.
if the seller is unable to offer vacant possession.
In your
These
first,
are remedies the Act confers upon the creditor simply by virtue of the notices having expired.
your first crave is really directed to the last few lines, which is about the power of sale, isn't it?
Yes, which is expressly referred to, but the respondents in that crave are seeking warrant from the court to exercise all of the remedies which would be open to a creditor whose debtor is in default.
Yes.
Within the meaning of standard condition 10.
Yes.
And that would then entitle the creditor to exercise not only the power of entering into possession, which isn't conferred on the creditor having served a notice of default, but would also, ultimately in my submission, of course, open up all of the remedies, whether conferred by standard condition 10 or by other enactments or rules of law, which are conferred upon a creditor who has served a notice of calling up a standard security. But instead of utilising either of these processes involving service of notices, Section 24 provides the creditor with a third alternative, which is to seek warrant from the court to exercise the remedies open to a creditor where the debtor in the security is in default. My Lords, my Lady, in addressing those two issues, which I say I'll label the default issue and the ejection issue, the second issue is, of course, whether the respondents are entitled to warrant to eject the appellants in circumstances where they haven't served a notice of calling up under Section 19. I would propose to make my submissions in 5 parts and under the following chapter headings.
Yes. Could you? So you're going to give us headings. Could you take this fairly slowly, and do please keep your voice up so that we can?
Yes. Yes. Sorry, my Lord. The first of the headings is simply the relevant statutory background, which I would hope to be able to take quite briefly, given the discussion which we've already had on the specific terms of the Act. The second is the terms of the standard securities. And again, I would hope to take that quite shortly because we have your Lordships and your Ladyship already examined in some detail the terms of the personal bonds and thereafter the grant of security in these securities. The third heading is simply the default issue. The fourth is the ejection issue. And the fifth is a summary of the principal legal submissions on which the respondents rely in inviting your Lordships and your Ladyship to dismiss these appeals. It may be convenient to begin with the standard conditions, and as we've seen the three standard conditions which are of particular relevance to the issues for determination here are standard conditions 8, 9 and 10 in Schedule 3 to the Act, which are found in tab 2 of the first volume of the authorities at page 38.
No, so far as 8 is concerned, you didn't follow that procedure.
No, my lord. The respondents did not serve notices of calling up of standard security.
Do they ever?
Yes, I understand they do, my lord.
Well, how do they choose when to do so, and what's the policy? How does it work?
I can't say I have instructions on the specific factors which might influence the decision in any particular case, but I am aware from my own experience that the great majority of lenders will very often use each of these different routes to the enforcement of their security, depending upon factors, obviously, which they take into account. Well, as I understand it, the policy of the respondents, at least, is to serve notices of calling up where the property has been abandoned. Because in that case, the expiry of the notice will immediately entitle the bank to enter into possession as well as to exercise a power of sale.
Hard to imagine that Parliament thought that was the only circumstance in which calling up notices would be appropriate, isn't it?
Well, it may well be. It may well be that depending upon the history of the relationship with a particular customer who is granted security, the bank will consider one or other of these options to be the appropriate one. But I understand that, at least in relation to the respondents, the general policy is to use a notice of calling up where the property has been abandoned.
That's a bit paradoxical, isn't it? Because if there's no one in personal occupation, it's not within Section 5 on any view, is it?
It's not within Section 5, but then there would be no requirement to rely upon Section 5 as a basis for ejection, my lord, if the property has been abandoned.
So if you serve the calling up notice, in these cases where the property is abandoned, you go to Section 20 to see what you can do next. Is that right?
Yes,
One assumes there's a default. The property is abandoned. There's no payment is tendered in response to the notice.
Then, as Lord Hope's indicating, Section 20, subsection 1 indicates that the creditor may then exercise such of his rights under the security as he may consider appropriate, and any such right shall be in addition to and not in derogation from any other remedy arising from the contract to which the security relates, or from any right conferred by any enactment or by any rule of law on the creditor in a heritable security. So the expiry of a notice of calling up without payment, of course, opens up a whole range of remedies to the creditor, both those conferred expressly by standard condition 10 of Schedule 3 to the Act, and those conferred by any other statutory provision or rule of law in relation to heritable creditors.
It's rather odd, as has been pointed out, there's a lot of duplication because what's in Section 20 reappears again in Standard Condition 10.
Well, indeed, my lord, and what appears in Section 20, subsection 2, again appears in Standard Condition 10 because subsection 2 provides that where the debtor is in default as aforesaid, the creditor shall have the right to sell the security subjects or any part thereof. And what appears in Section 20, subsection 3 again, at least overlaps with, if it doesn't duplicate, the terms of another standard condition in Standard Condition 10, because there we see that a creditor in a standard security who's in lawful possession may let the security subjects or any part thereof for any period not exceeding 7 years.
Basically, what you're saying is that the use of really either of the notice procedures in sections 19 or 21 makes a lot of sense, where you expect to be able to get your way without going to court.
Well, indeed.
But if you think you may need to go to court, you will be inclined to use section 24.
Yes, yes. My lady is absolutely correct, I think. And I think that's probably a clearer explanation of the rationale underlying the respondent's policy, because these are remedies which the lender can exercise at its own hand, provided, of course, it's practically possible to do that. But in circumstances where the borrower is in occupation and is not indicating that he or she is likely to be cooperative, then the lender in that case would, as a matter of practicality, be obliged to rely upon the provisions of section 24 and apply to the court for warrant to obtain warrant to exercise the remedies required.
I'm completely puzzled by this. I mean, we read that Professor Halliday was the architect of this Act. I mean, what is the architecture here? I mean, how does it work? I mean, why does section 20, subsection 3, deal specifically, for example, with 7 years and so on, leases, in that situation? And why do we have something about, granting of leases, the right of the debtor to grant leases transferred in standard condition 10.5? I mean, I simply can't follow what's going on.
Well, I think there is some difficulty, my Lord, in trying to analyse the Act and the schedules in some entirely consistent and coherent manner. The difficulty that may have faced the framers of the Act is, of course, that on the one hand, what Parliament is seeking to do is introduce an entirely new form of standard security, which deals with the problems that it was perceived had been caused by the previous forms of security. And if your Lordships and your Ladyship are minded to consider the terms of the report of the Scottish Law Commission chaired by Professor Halliday, really the mischief that was identified was the inflexibility of the existing forms of security in a commercial situation, because a bond and disposition in security had to be granted for a fixed amount. A cash credit bond and disposition in security could be granted for a fixed amount and make provision for additional lending, but the amount of additional lending had to be determined at the time the bond was being granted, and therefore it was subject to a maximum. So the mischief that the Commission identified was that inflexibility. Unfortunately, the Commission don't appear to turn their minds to the practicalities of enforcement of the new form of standard security. But on the one hand, they were seeking to recommend a new form of standard security. On the other hand, the 1970 Act, as it was obliged to, had to continue to regulate the many hundreds or thousands of heritable securities which had been granted in the old form prior to the coming into force of this Act. And it may be that in attempting to make provisions that were intended to deal with both those situations...
Well, it didn't deal with... I mean, all it did, surely, was to leave as intact the existing law, didn't it? As far as the old forms of security were.
Yes, but also, my Lord, to apply to standard securities insofar as those provisions weren't inconsistent with the 1970 Act, those old provisions.
Absolutely, and they excluded certain bits and so on and so forth.
Yeah.
But as far as a previous, I mean, whatever the date was in November of that year, whenever it was that they suddenly all changed, the other ones carried on under the same regime.
Yes, my Lord. But I'm simply sort of, I'm not in a position to myself...
No, I just don't understand. I don't think it explains very well why we have these different things about the length of leases and powers to lease and so on. I can't follow it.
Well, they all apply only to standard securities anyway.
Yes, absolutely, yes. Precisely.
They're not changing
No.
anything relating to, if I may call them, non-standard securities.
The old securities.
But as I understood under the old law, the position was that 7 years, I think, was the maximum period for which a heritable creditor under an old form of heritable bond could let without requiring permission. And I think in some way the Parliament is intended, insofar as it can, to try and ensure that certain provisions run in parallel. But I'm not in a position to explain to your Lordship and your Ladyship why it is we find provisions that are apparently being duplicated in the sections of the Act and in the schedule.
I mean, do I understand this, broadly speaking, paragraph 10, or whatever it is, of the schedule, gives you various powers. But then how you can exercise these powers, you have to go back into part 2 of the Act to see how, in any particular situation, you can. Is that right? Because it says, in accordance with the provisions of part 2 of the Act.
Yes, indeed, my Lord. Yes.
Is that the structure?
That is how I would understand the structure. It may be that what is provided for in Standard Condition 10 is sufficient in circumstances, for example, where the borrower has already vacated the property, because then nothing further is required to assist the creditor. But if there is any practical difficulty in exercising these remedies, then one is driven back, as my Lord Rogers says, to part 2 of the Act to see what ancillary remedies or procedures are available to the creditor.
No, I think part 2 may restrict, because, I mean, as you yourself just pointed out, whereas it says that somebody may enter into possession, the creditor may enter into possession, as you yourself pointed out, you go back to section whatever it is, and 9(1)(b) creditors can't do that because they can only do the things which are provided in that section to which you refer.
Yes.
It's a most peculiar.
If the Act had provided that all the special conditions should be set out, even in small print, in every security, that every standard security that was ever granted, that would explain why there would be a degree of duplication. But it didn't. And looking at your bank's form of security, it certainly doesn't set out all. It only sets out the variations in the special conditions.
Yes, my Lord. But the unless varied, the standard conditions are deemed, yes, to be...
Yes, I'm not being critical. I'm just trying to find some explanation of why there is so much duplication. It is a bit of a puzzle.
At any rate, do I understand the distinction you're pointing us to between Section 20 and Section 24 is that Section 20 simply declares that you're entitled to exercise the rights referred to there, and because it's declared to do that, you can simply go ahead and do it unless there's an obstacle in your way, particularly because the debtor is still in possession. And because you can't remove him from the premises without an order of the court, your practice, the bank's practice at least, is to use Section 24, which requires a warrant to exercise the remedies to which it refers.
Yes.
So it's a warrant process as opposed to a self-help process.
Indeed, my Lord. And I would say further that perhaps the process of obtaining a warrant can be likened to the obtaining of a declarator in an action of declarator and removing, whereas a necessary preliminary to a decree being granted for removal, the creditor or pursuer obtains a declarator of the right to do that. Under Section 24, I submit that when the creditor makes application, and the application includes application for warrant to eject, then the creditor has to obtain warrant in terms of Section 24 to exercise the remedies set out in Standard Condition 10 before then being entitled to warrant to eject in order to put the exercise of those remedies into practical effect.
But does he need Section 5 of the 1894 Act at all? That's the basic question.
Yes.
Supposing you have an owning occupier who's in your way.
Yes.
Does he?
Well, certainly the process of reasoning which led the extra division in the court below to their decision was that Section 24(1) read short indicates that the creditor in a Standard Condition 9(1)(b) default is to be put into exactly the same position as the creditor who has served a notice of calling up, that is to say a Standard Condition 9(1)(a) default. That it's apparent that the creditor who has served a notice of calling up, which has not been complied with, is entitled to ejection in terms of Section 5 of the 1894 Act. and accordingly that the legislative intent underlying section 24(1) is to entitle the court to grant warrant putting the 9(1)B creditor in exactly the same position, that is to say, in the position where he or she is entitled to eject.
If they go through, if they give the requisition.
Well, no, my lord.
No, you say.
No, I say, because the whole point is that the
That's right.
standard condition 9(1)B creditor doesn't have to
9(1).
be standard condition 9(1)B, that is any default other than failure to comply with a notice of calling up. I say that standard condition 9(1)B creditor is by virtue of section 24 subsection 1 deemed to be in the position of having served a requisition, because there is given to him all the remedies open to a creditor who has served the requisition.
So you're founding on the last 2 or 3 lines of section
Yes.
24(1, are
Yes.
you? And the phrase, exercise any of the remedies which is entitled to exercise on the default within the meaning of standard condition 9(1)A.
Yes.
But that actually begs the question, which I'm putting to you, because it's possible that section 20, which is the remedies once you've done your calling up, doesn't actually include the right physically to remove proprietors who are in personal occupation.
You know, I accept, my lady, that there is no express provision to that effect. What I say is that section 20 subsection 1, by indicating that the creditor who has served a notice of calling up may exercise such of his rights under the security as he may consider appropriate, and that such right shall be in addition to and not in derogation from any other remedy arising from the contract to which the security relates, or from any right conferred by any enactment or by any rule of law on the creditor in a heritable security, is opening the door to the remedies available under Section 5 of the 1894 Act.
Yes, but section 5 is subject to the proviso.
Yes, but perhaps then I could just take your lordships and your ladyship to Section 5, because Section 5 does not make it necessary that a requisition has been served before the proprietor can be ejected. That's Volume 1 of the Bundle of Authorities at tab 5. And your lordships and your ladyship will see, if we look at the proviso, that what is said there is, provided that this section shall not apply in any case unless such proprietor has made default in the punctual payment of the interest due under the security, or in due payment of the principal after formal requisition. And in my submission, the way in which that proviso has to be read is that it's only the failure to make payment of the principal which has to be the result of a formal or consequent upon a formal requisition.
The sheriff was against you on that, wasn't he?
My lady, the sheriff was against me.
On everything, yes.
The sheriff was against me on absolutely everything, yes.
I'm not sure I've grasped the proposition. You're saying only if there's a failure to make payment of the principal that
Yes,
you need to have a formal requisition.
Lord, yes, I see the punctuation indicates there that there are 2 failures which give rise to the right to eject. One is a failure to make payment of the principal after formal requisition. The other is a failure punctually to make payment of interest. As my Lady Hale has correctly pointed out, the learned sheriff is entirely against me on that submission, but the court below, the extra division, were with me, and in my submission, that is the...
Does this depend upon the comma?
It does, my lord.
And I've rather overwritten mine. I can't now work out where the comma is.
The comma...
So after security.
After security,
Yes,
but not elsewhere.
Before or, yes.
No, that's the only comma. But I'm not sure I quite understand this. What you were asking for, what the bank was asking for, was payment of both principal and interest, wasn't it?
Yes. The only point I seek to make is that, that it is not an essential requirement in terms of Section 5 of the 1894 Act that a formal requisition has been made. Because if I'm well founded in the construction I'm advancing to your lordships here, under Section 5 of the 1894 Act, the creditor in a heritable bond is immediately entitled to eject if there has been a failure punctually to pay interest. And no requisition or prior notice is required.
What's the rationale for that? And why draw a distinction between interest and principal?
Well, it's difficult to see. It may be that the borrower is to be taken to know that interest is due on specific dates, and if he or she simply neglects to do so, then that is such a grave breach of the terms of the parties' contract that it immediately gives rise to the credit.
Whereas repaying the whole principal, whole of the principal, is not a grave breach.
Well, no, but the section appears to envisage that what is secured will be a loan which is perhaps not repayable on a particular term, and maybe an overdraft repayable in demand.
It's very odd because in the, if one looks at the titles of the Land Consolidation Act of 1868, the form in the schedule refers both to principal and interest, which makes it very difficult to see why the two should be different.
Well, I think I must...
That's page 840, tab 10.
But that may be, my lord, because even if one were serving a requisition for payment of the principal sum, the form would, I think, provide for reference to be made to any further interest that might have accrued and be due at the same time as the principal sum. What Section 5 of the 1894 Act, as I read it, is indicating is that even without the principal sum becoming available, a failure to pay interest punctually will in itself give rise to the creditor's entitlement to enforce the bond by means of ejection.
But if you look at section 119, this is looking at page 790 in tab 8, near the bottom, it again seems to tie in the requirement for Form 2 to demands for payment extending to payment of the sums that should be due by personal obligation, and that would seem to include interest as well as principal.
Yes, but I would suggest, my lord, the explanation for that might be that, of course, these are demands for payment on a particular future date, and therefore it would be necessary to provide for the further interest which will have accrued between the date of demand and the date by which payment is due in terms of the demand. But that is simply a means of requiring payment of the principal with any further interest which might have accrued upon it. In contrast to that construction of Section 5 of the 1894 Act, which I'm advancing, it may be, convenient simply to note at this stage that, as I think has already been mentioned this morning, the law has changed quite dramatically since the enactment of the 1970 Act, and by virtue of the Mortgage Rights Scotland Act 2001, there has been, since December 2001, a requirement on creditors seeking to exercise or follow any of the routes for enforcement, that is, serving a notice of calling up, serving a notice of default, or applying to the court under Section 24 for warrant to give notice,
Yes.
not only to debtors or proprietors, but to other occupiers of the properties.
This is the new subsection 3, is it, of Section
Yes,
24?
there are copies, certainly of the relevant provisions at tab 6 in the first volume of the authorities, the copy of the provisions there. Just read short, if your Lordships and your Ladyship have that. Section 1 indicates that it applies to a creditor in a standard security over an interest in land used to any extent for residential purposes has either served a notice of calling up or a notice of default or made an application to the court under Section 24 or separately commenced proceedings under Section 5 of the 1894 Act. Subsection 2 indicates the persons who are then entitled to make application to the court. And Section 4, which begins on page 340, in the pagination here, it sets out the provisions regulating the notices which, since December 2001, have required to be served by creditors attempting to enforce the standard security by any of these means.
So what do we learn from that?
Well, I refer to it simply to say, to your Lordship, that clearly the landscape has changed considerably since the 1970 Act was introduced, and the scope for determining in this appeal future procedure in other cases may be rather more limited than otherwise it would have been. But I quite accept that in considering these issues, your Lordships and your Ladyship, of course, are dealing with the 1970 Act in its full contractual rigour, and before the introduction of the provisions in 2001 and subsequently this year in the 2010 Act, which give the court a much greater role and give the court a discretion as to the extent to which a creditor is to be allowed to enforce his standard security. We are dealing with...
Is that is the Section 2, is the 2010 Act in the...
Well, the 2010 Act, it's not, I'm afraid, my Lord, it only came into force, I think, on the 30th of September. It's not in the bundles of authorities, but certainly we have copies which we can make available if that would be of assistance.
What's the Act called?
It's the Homeowner and Debtor Protection Scotland Act, 2010.
And the ASP number?
It's ASP 6, my Lord.
ASP 6?
6. And we will ensure that copies are provided. But as I understand it, in essence, the main effect of that Act has been to extend the court's discretionary powers conferred by the 2001 Act and to place even further upon the creditor the onus of satisfying the court that it is reasonable that the lender is entitled to take possession of the property.
So I suppose you can take from that the fact that Parliament has seen fit, required to legislate in this way, indicates that the previous regime was unduly harsh.
I could take from that, yes. I might not use those precise words, I think. I would just say contractually rigorous.
Well, rigorous is what... Rigorous is your word, yes.
Yes.
And as regards your point about the comma in Section 5, in the proviso to Section 5, I'm not quite sure what you're making of it, but a very remarkable feature of your standard security, to my mind, is that what it says about interest is that interest shall be paid at such rate as the parties agree, or in default of agreement as the bank fixes. It appears to me to say nothing at all about when interest is to be paid. So how do you tell whether it's been paid punctually or not?
Yes, I don't submit, and perhaps I should have made this clearer, I don't submit to your Lordship that I'm entitled
to found in that.
Yes, to found upon that. No, I was simply submitting that if we were viewing matters on the basis that the 1894 Act makes a requisition necessary and that somehow the bank are trying to avoid that. I say it's not always necessary under the 1894 Act to do that, because a creditor, I say, under the 1894 Act can eject if there's been a failure to pay interest punctually.
But just to see how it works in practice, your bank has the standard security, and then you have some other letter which actually sets out what the real deal is, does it?
Well,
The rate of interest and when interest is to be paid and so on.
Yes, I think it would be fair to take it that there is a provision my Lord Walker's referred to in the standard security as to interest, but the loans secured by the standard security will each be subject to loan agreements or contracts, which I think one can take it will make provision for particular rates of interest and when that interest might be payable. But I don't say, because the partnership loans which were part of the sums secured here are current account or overdraft lending, then there is no evidence to indicate there was an agreement on particular termly payments of interest. So I don't suggest in this case I can found upon that part of the proviso of Section 5 if my construction is the correct.
Because you would need to find the interest under the security, apart from anything else.
Yes.
And you're just, I mean, there isn't, you're not founding on that, you see.
I'm not, my Lord, no.
So we can forget that. So how does it work then? I mean, what is your submission as far as Section 5, the tailpiece, is concerned? The proviso.
My submission as to how that applies in relation to the respondents in this case.
Yeah.
Well, I will try to take your lordships and ladyship through that in a little more detail, but put as baldly as I can, my submission is that by virtue of the terms of Section 24, subsection 1, the respondent as creditors of a debtor who is in default within the meaning of standard condition 9.1b are entitled to exercise all of the remedies open to a creditor whose debtor is in default within the meaning of standard condition 9.1a, that is to say, the notice of calling up creditor, and that those remedies, by virtue of Section 20, include the right or the remedy of ejection conferred under Section 5 of the 1894 Act.
Oh, I see, but I mean, but it takes you back to, but you can only use that if it says at the end, provided that, and there's a proviso.
Yes, but well, perhaps I've missed out a stage or two in the reasoning in that case.
It's the requisition.
Well, what I'm saying briefly is that both classes of creditors are placed in the same position by the Act.
Well, at some point, both of them will have to rely on Section 5, will they?
Well, in order to obtain actual possession,
yes.
If the security subjects aren't vacant, both of them will require to evict, to use a neutral word, the borrower.
And if it's a personal proprietor in occupation, Section 5.
Yeah.
Then requisition. Oh, you say no, and that's the bit I'm not quite got yet.
Yeah, well that's why it may be necessary for me, maybe better for me to take your lordship through the argument that underlies that submission on the step-by-step basis I was hoping to do, but I was simply trying to assist, and I probably haven't, by setting out boldly the final conclusion that I'm urging.
Well, at least we know the target.
Well, yes.
As I understand it, your opponent accepts that a calling up notice issued pursuant to Section 19 would amount to a formal requisition.
Yes. Indeed, my lady.
But of course, your real dispute is that he says, and you need something equivalent.
Yes.
If you're proceeding under 9.1b.
Yes. Whereas, put short, I say, no, I'm deemed to have done so. I'm deemed to be in that position by virtue of sections 24 and section 20. But clearly I require to...
But you're deemed to have complied with the with the obligations which are on somebody who has served a calling up notice. No, you're trying to escape those, aren't you? I mean, your whole purpose is to escape the requirements of somebody who served a calling up notice, because that would be disastrous from your point of view. And that's the whole purpose of all this, and that's the forensic purpose of all this, isn't it?
Yeah.
And what's the sense in that? I mean,
because I say because...
I mean, why would Parliament have enacted any such thing?
I say because if we consider the terms of the Act and the standard conditions, Parliament has certainly intended to put both classes of creditor in the same position as to the substantive remedies that are open to them.
But they're not in the same position.
Well, as to the substantive remedies of entering into possession, selling the property, and so forth. That is what Section 24 does. The creditor who simply serves a notice of default is not put into the same position as the creditor who has served a notice of calling up.
You're putting a lot of weight then on the last few words of Section 24.1.
Well,
that's where you say, in effect, the deeming provision is to be found.
Yes.
Because having got to the position of a default within the meaning of 9.1b, you may apply to a warrant, and the application is made on the basis that you're entitled to exercise any of the remedies that you would be entitled to exercise under 9.1a.
Yeah, and I say it's significant, my lords and my lady, that
Actually, the draftsman missed the comma point.
No, what I say is the draftsman could have said you will be entitled to exercise all the remedies conferred by Standard Condition 10. Why is it that the language that's been used directs one back to the remedies available to a creditor who has served a notice of calling up?
But we're still back to the same point, that creditor needs to comply with Section 5 to evict the personal occupant. He has done so because his calling up notice is good enough.
Yeah. Well, I entirely take my Lady Hale's point, and I will take your lordship through the argument in slightly greater detail if I can, but I see I'm a bit...
We've reached really 4 o'clock now, and this may be a convenient point at which to break, but I think you should be aware that we, for various reasons, will have to rise no later than 3:30 tomorrow, and I would hope, if it's possible, you could finish by lunchtime. I don't know how much time you think you're going to need to set your argument out, but...
My lord, I would certainly be very surprised if I weren't finished by lunchtime tomorrow, if not sooner than that.
Yes.
And I'll certainly, bearing in mind your lordship's and your ladyship's commitments, make every effort to ensure that I certainly am finished by or before lunchtime tomorrow.
But to allow Mr. Summers an opportunity for reply if he wants
Indeed.
to.
Indeed.
Thank you very much. Well, 10:30 tomorrow morning.